May it please the court, counsel, and members of the courtroom. My name is Tanya Oliver, and I represent the petitioner, Steven Appel. Before you, Your Honor.
And before we begin, how much time would you like for rebuttal?
Oh, I apologize. I would like to reserve 5 minutes.
5 minutes? Very good, ma'am.
Before this court, the petitioner made a claim to the City of Tampa Pension Board requesting an in-line of duty disability pension. He appeared before the pension board in a quasi-judicial hearing where at the informal hearing where he was not represented, his application was denied. Following that, he went forward with a formal hearing, and at the formal hearing, after having testimony of physicians and himself, again, his application was denied. It is the petitioner's contention that the circuit court, as well as the pension board, failed to apply the correct law. That is why we are before you here today. The circuit court misapplied the holdings in Bivens versus City of Lakeland when it found that Firefighter Appel's angina had not met the statutory requirements of a protected condition.
Doesn't the case law say that a court can, if it applies the cases or the case law or the statutory law even incorrectly, it doesn't meet the standard for a second-tier cert. In order for a standard for a second-tier cert to apply, the lower court must have engaged in an action that's tantamount to judicial tyranny. In other words, total disregard for the law, not even going to the correct cases, even if they may not interpret the cases the way you think they should. It's a real high standard here, so explain to me how you are going to get around that.
Your Honor, in looking at the case law in Bivens, which is the final holding by Judge Nelson in his order that he followed the pension board's assertion that the presumption did not apply, the correct law was not applied either statutorily in the presumption of 112.18 being applied or by the case law. Florida Statute 112.18 is a very unique statute which was embodied or enacted as a legislative act to protect first responders and the hazards of their duties. It is not their job, in order to establish the presumption, to rebut the presumption with causation. Instead, what they must do is establish that the 4 elements of the presumption apply. I believe that's where the statutory law was misapplied both by the pension board and by the circuit court. In order to establish the presumption, they must establish, 1, that they are a protected class of firefighters, law enforcement, or correction officers. 2, that they have a protected condition.
It's only the fourth prong of that that's at issue here, isn't it?
Correct. It's the protected condition of heart disease.
And I thought Judge Nielsen did a pretty good job of laying out that the 4 doctors that testified, none of them found that the condition was heart-related.
And that's where I believe the error was in the Bivens case, which was cited by the pension board and cited by Judge Nielsen. What the first responder has to establish or has to prove is that he has a condition. He's been diagnosed with angina. The angina is the heart disease. If you look at his order, he goes and makes a leap from October 3rd, 2014, which is a disabling event, to the actual application of July 15th, 2015. And that's why all the doctors in the medical records, all that evidence was placed into evidence, because at the ER could not find a basis for the chest pain. They noted he had hypertension, they noticed he had heart disease and coronary artery disease, but they could not find a basis for the chest pain. His workers' compensation doctor, Dr. Fernandez, did every workup possible before diagnosing him with prinzmental angina, and once he was diagnosed with that, he carried that disease. That's the disease that took him out of work, and that's the heart disease. And that's where I believe Bivens was misapplied. Bivens is a case directly on point which says angina is a form of heart disease. It's a compensable condition. And once he's met that compensable condition, that 4th prong, the other 3 prongs having been met, it is then the burden of the other opposing party to prove causation, not Mr. Appel. And that's where the statutory case law was also misapplied, because in essence what happened is the pension board and the circuit court is requiring Mr. Appel to prove causation for his heart disease when it's already an established disease condition as diagnosed by his treating physician. I will also further go into, Your Honors, the medical records for...
It sounds though like your position is not that Judge Nielsen didn't apply the correct law, he just was wrong in his analysis of that law.
Correct.
That's not second-tier cert.
He is wrong in his analysis and the application of the statute, and it's the misapplication of the statute that gets to the second level. By misapplying the Heart Bill, which was enacted by the legislature as a social expression of public policy to protect first responders, he ineffectively denied Mr. Appel his due process and ability to receive his line of duty disability pension.
But there also were experts who testified that the angina was not a heart-related disease, is that right?
I believe that is incorrect, Your Honor. What they indicated is that the heart disease is a differential diagnosis. The Prinzmental angina is a differential diagnosis of heart disease. So while medicine and science are not black and white like the law, they ruled out everything else from October 2014 when he was diagnosed to July of 2015. They did all kinds of tests on Mr. Appel. In doing all those tests, they could find no cause but for the angina, which was his heart disease.
So in Judge Nielsen's order where he went through the experts that he said did not connect angina to a heart disease, was he misstating the facts, or he took a position contrary to what you just said?
I believe that the order in which Judge Nielsen wrote summarized Dr. Bonacker, who is the pension board's medical expert, who indicated that it was a non-cardiac condition, that angina was a non-cardiac condition. My assertion on behalf of Mr. Appel is that he does not have to prove that. What he has to prove is that it's a form of heart disease, and he did so through all the differential diagnoses and final diagnosis by Dr. Fernandez, his treating doctor, who diagnosed Prinzmental angina as heart disease. So in looking at the statute, as I indicated, it is a presumptive statute. Once he's met those four criteria, once Mr. Appel has established those four prongs, including the fourth prong of heart disease, it is then the burden, the shifting burden, to the opposing party to prove with clear and convincing evidence a non-occupational cause. The board skipped that whole step. They did not apply the presumption, and neither did Judge Nielsen. And in not implying that presumption, they violated the statutory construction of Florida Statute 112.18.
Thank you.
Thank you.
Good morning, Your Honors. May it please the Court. Robert Klausner for the Board of Trustees. As Judge Morris noted, second-tier certiorari has a very high standard. There's no claim here that there was an act of judicial tyranny. There's no claim here that there was an overreaching by the court. It's a disagreement over the law. And as I noted in my sister's...
If I
Yes,
may,
ma'am.
I think what Ms. Howie is making the argument, I want you to have the chance to respond. As I hear her argument, she said that where the failure of the application of the correct law is that the presumption was not applied. And had the presumption been applied, then the burden would shift to the other side to bring in by clear and convincing evidence or by whatever evidence that it is not within the statute. I think that's her argument. How do you respond to that?
Well, the answer is, in order for the presumption to apply, whatever is determined to be cardiac in nature has to be the disabling condition. That's what Bivens was about. The firefighter in Bivens had a heart disease, but it wasn't disabling. In this case, we had a factual determination by the Board of Trustees based on its analysis of the medical examiners, and then affirmed as being based on competent substantial evidence by Judge Nielsen that the angina was A, not cardiac in origin, and B, that it was not the disabling condition. So the presumption doesn't come into play because you have to meet all four of the conditions in order for that to apply. And I think what my sister has done is tried to engraft a workers' comp standard onto what pension boards do. And this court said in City of Tampa versus Lewis that different purposes, different standards, and different statutes. You know, we have a fiduciary duty to our members, our police officers and firefighters here in the City of Tampa, to grant them a benefit when it's due and to deny it when it's not. And in this case, Mr. Appel failed to meet the standard by establishing those facts. As the 4th District Court of Appeals said in Franza, when a pension board's faced with multiple doctors, as the trier of fact, it gets to choose which one of the witnesses convinced it. In this particular case, the Board of Trustees determined that based on the evidence that it heard, that the disabling condition was not cardiac. The cardiac elements which were identified, all of the doctors agreed were well controlled and not disabling. So the presumption would not apply. Judge Nielsen's review, his job on review in first-tier certiorari, was to determine whether or not the board's action was based on competent substantial evidence, and he did. The big difference between first-tier and second-tier certiorari, which brings us here today, is the facts are settled. We are not going into that. In fact, in my sister's initial presentation, she focused on the facts, but that's not before you. That's a settled question. Had the facts been that the angina was cardiac and that had been a fact established and affirmed, we probably wouldn't be here. He would have been granted the disability, but that didn't happen. And so as a result, Judge Nielsen was correct. And I think what's interesting is here, this court has the advantage of two opinions. It has a detailed opinion from the Board of Trustees outlining its thinking. And perhaps more importantly, you have the advantage of Judge Nielsen's thoughtful opinion. This isn't just an order that said granted or denied. You have the advantage of being able to look into what he saw. And what he was supposed to do is, was there an error of law? No. Were the facts based on competent substantial evidence? Yes. And due process, which is the third element, isn't present. For all of these reasons, we believe that Judge Nielsen's order is correct. He correctly affirmed the Board of Trustees, and the petition for certiorari should be denied. And I'd be happy to answer any additional questions that the court has.
Any questions?
Thank you.
Thank you, sir.
May I approach the podium?
Yes, ma'am. And you have your 5 minutes for
Thank you.
rebuttal.
I first want to make a distinction in Bivens, the case that counsel cited. Bivens finds angina to be cardiac disease. The case law out there finds angina to be cardiac disease. So the question of fact of whether the presumption applies is already answered. Angina is heart disease. What is confusing, and which I think the board erred in writing its order, is that angina, which was found to be totally impermanent in Mr. Appel's case, was not found to be totally impermanent or disabling in Mr. Bivens' case. The fact is, angina is still heart disease. Therefore, Mr. Appel met the 4 criteria of the presumption embodied in Statute 112.18.
But as I understand, Mr. Klossner's argument is he agrees with you that there's a presumption, but he also indicated that if you have to find angina, which in this case there is, but then you also have to have the finding that it was disabling. And as I understand Mr. Klosser's argument, that becomes factual determination for the trier of fact to determine what was presented to him in terms of the testimony by the expert witnesses. And based on that factual determination, came to the conclusion that hypertension was the one that was most disabling and that angina was not. So based on that, as I understand his argument, the presumption doesn't even kick in, and therefore, at our level here, we can't debate the facts, as you know. We have to accept what's presented to us. We just need to make a determination, did the court below totally, to use Judge Morse's term, totally misapply, totally miss the boat on this? So how do you respond to that?
Well, I think that Judge Nielsen did misapply the statute of 112.18. And in answering your question, the pension board already found that Mr. Appel was totally and permanently disabled. The question is whether angina was heart disease. And that's the question that I believe was overlooked by the pension board, as well as the Judge Nielsen at the appellate level, because angina is heart disease. There's no dispute that it is heart disease. The presumption should have applied, and it was then the burden of the pension board to rebut that presumption. And looking at that social policy and looking at the Caldwell case, which was cited in my briefs, the Caldwell case embodies that should the diagnosis be one of heart disease, and we don't dispute that he has hypertension and coronary artery disease. He actually has 3 conditions. The other 2 were not disabling. It was the angina that took him out of work after serving 20 years as a firefighter. It was the angina that was the 4th prong of the criteria of the presumption, and that the presumption was not applied correctly pursuant to the statutory and the case law in Bevins that cites that angina is heart disease. I would respectfully request that this court review that issue and find in favor of Mr. Appel and reverse the pension board and the writ of certiorari decision and grant him his line of duty disability pension.
Very good. Thank you,
Thank
ma'am.
you.
Thank you both.
Thank you, Your Honor.
Thank you.